Welcome everyone. Thank you for coming to the Wisehour Legal Learning Table. Today we have Sharon Blake from the New South Wales Law Society with us, and Sharon comes to us with a wealth of knowledge, and she's got a whole bunch of wonderful insights to share about trust accounting and why it's important and how to keep on the right side of the trust auditor. I give a warm welcome to Sharon from the New South Wales Law Society. Thank you.
Oh, Sharon.
Hello, everybody. Now I'm going to try a magic of trying to share my screen. And
Can you
wish me luck.
Yep.
And hopefully there should be a screen coming up through now, where law and money meet, the crucial role of a solicitor's trust account. Can you all see that?
Yes.
Excellent.
Yes, I can.
All right. Well, thank you, Karen. And as Karen mentioned, I am Sharon Blake, the Chief Trust Account Investigator at the Law Society of New South Wales, but I'm also the head of the Trust Accounts Department. I'd like to have a huge thank you to Karen and the team at Wisehour for the opportunity to meet you all virtually today, and thank each of you for joining the presentation. And before I begin, I'd like to acknowledge the traditional owners of the land which we gather here today, and pay my respects to elders past, present, and emerging. And I extend that respect to all Aboriginal and Torres Strait Islanders people joining us today. So, who are we in the Trust Accounts Department in New South Wales? What do we do? Well, our job is to ascertain if New South Wales law practices have complied with their obligations under 4.2 of the Uniform Law. And that is to ensure that trust money is held in a manner that protects the interests of the persons for whom or on whose behalf it is held. Now that sounds easy enough, right? Well, it would be, except for there are about 370 odd rules and obligations regarding the administration of trust accounts. Now, we also play an important role in trust account assurance. We accredit and oversee the external examiners and their reports. We conduct investigations arising from notifications of trust account irregularities. We review the quarterly statutory deposit request for determination. And we educate the profession through events like this, continuous learning education, and practice management courses. We accredit trust accounting software providers like Wisehour, and they're all listed on our website, and we provide advice on trust-related matters to the solicitors across New South Wales. We liaise with the other trust account regulators across Australia, New Zealand, the UK, and Ireland, of course, Canada, Hong Kong, and Singapore. And that's really to continuously strive to improve our regulatory approach. The legal profession continues to grow in New South Wales with about a 5% annual growth last year and 4% average growth year on year since 1997. So, as you can imagine, we're kept pretty busy. So, what are we going to do today? So my goal for each of you attending here today is to come away with a knowledge of what does trust account compliance look like? What are the key components of compliance? Now, Karen has also asked me to deal with how do you mitigate the risks around trust accounts? What are the common avoidable mistakes? What happens if your trust accounting software gets it wrong? How do you manage the external examination, or sometimes known as the audit? And how do you handle mistakes? But I'd also like you to come away from today with how do you keep your trust account secure, but not just your trust account. Apply these learnings to all your office accounts, your bank accounts, your personal accounts, and send it to your family and friends too. And also to understand what's happening across the regulatory landscape. So throughout today, please feel free to ask any questions, jot down your notes, shoot them through to me afterwards, or pop them into the little chat box here on the screen. So, trust accounting. It's not just a checkbox. It is the lifeblood of the profession. And I love to open with this quote because members of the public do put great faith in the honesty of solicitors in handling money on their behalf. Reliability and integrity in the handling of this money is a fundamental prerequisite in determining whether an individual is fit and proper to be entrusted with the responsibilities belonging to a solicitor. So, what is trust accounting? Well, to understand trust accounting, you need to know what accounting is. And well, it's accounting is a tradition as old as money itself. Now, the earliest recorded evidence of accounting can be traced back to ancient Mesopotamia and is closely related to the development of modern writing, counting, and money. Even the ancient Babylonians and the Egyptians were performing audits. Now, those pyramids must have cost a fortune to build. So, you may not be surprised to hear that by the time of the Roman Empire, the government had access to detailed financial information. But modern accounting got its real start with the writings of one man, Luca Pacioli, and excuse the Italian pronunciation, hailing from Italy. He was the first person to publish a book on double entry bookkeeping, introducing his ideas to the Italian people. So he's commonly referred to as the father of accounting and bookkeeping. And the official profession of chartered accountants actually originated in Scotland in the 1800s, and solicitors would often employ these accountants to offer their services to clients. And the first organised institute of modern accounting was formed in England in 1880 and in Australia in 1905. And so from there, the rest is history. So, why would you have a trust account? Well, you want to protect client monies. But it's also legal and ethical requirements to manage specific types of money in accordance with the rules. Now, I'm an accountant, not a lawyer, but from a commercial perspective, I'd say to you, if you're not receiving between 70 to 85% of your fee earnings through a trust account, you're going to be struggling financially to be getting your bills paid on time. Now, we know poor cash flow is responsible for 90% of business failures, and recent payment data shows us that 38% of business invoices are not paid on time. A trust account also assists you grow your practice and supports scalability and reduces disputes as you will maintain detailed trust accounting records. So, what are the components of trust account compliance? Well, you need to have a detailed knowledge of the trust accounting legislation, obligations, responsibilities, and trust account supervision. You need to know what is and isn't trust money, and you need to know the record keeping requirements of the various types of trust money and the relevant key dates. You need to complete your annual submission. This is known as your Part A, B, and get the external examiner's report done. Here in New South Wales, it's through the Trust Lodgement Portal. You need to restore trust account deficiencies, and you need to notify the Law Society of any actual or suspected trust account irregularities. So, what is the relevant legislation? So, since about 2004, all states and territories, with the exception of South Australia, have enacted their legal profession legislation on the basis of a national model bill. A single national framework for legal profession regulation was not achieved because of variations between jurisdictions. New South Wales and Victoria adopted uniform law on the 1st of July 2015, and Western Australia adopted uniform law on the 1st of July 2022. So a lot of what I'm talking about today is from that uniform law perspective. The uniform law has created a single system to harmonise the regulation of about 74% of the Australian legal profession, cutting red tape and creating a single system to govern legal practice. Now, I've included in here a link, and I'll share these slides with you after the presentation today, to each of the relevant trust excerpts from the New South Wales legislation for ease of reference, including sections 127 to 168 of the Uniform Law. And these relate largely to trust money and trust accounts. Rules 33 to 69 of the General Rules, and these relate to trust money and trust accounts. Rules 93 to 95A of the General Rules, which relate to registers that need to be maintained. Section 11 of the Application Act, which designates the Law Society as the designated local regulatory authority here in New South Wales. Section 14 of the Application Act relates to unclaimed money, and Section 46 and 47 of the Application Act relate to statutory deposits. Rules 9 to 12 of the Application Act relate to the calculation of the statutory deposit, and that varies from each jurisdiction. So, what are your obligations? Well, a principle of a law practice is responsible for ensuring all associates comply with their trust obligations. Section 34 states that each principal of a law practice is responsible for ensuring that reasonable steps are taken to ensure that all legal practitioner associates of the law practice comply with their obligations. Under this law, subsection 35(1) of the Uniform Law provides that if a law practice contravenes any provision of the Uniform Law or rules imposing an obligation on the law practice, now whether by act or omission, a principal of that law practice is taken to have contravened the same provision if the principal knowingly authorized or permitted the contravention, or the principal was or ought to reasonably have been in a position to influence the conduct of the law practice in relation to the contravention of the provision, and failed to take the reasonable steps to prevent the contravention. Now, you will note that reasonable steps is not defined in either circumstance, but I always recommend best practice in this area to include having really good, sound, thorough business practices, efficient governance arrangements, and systems and tools in place that are genuinely protective in character. And it is important to note that failure to comply may constitute unsatisfactory conduct or professional misconduct. Now, a recent case I was involved in dealt with a principal of a law practice who wasn't aware that their employee solicitor was doctoring invoices to include their own personal bank account details instead of the law practice's bank account details. And when asked, the employed solicitor responded that, well, they were provided with PDF editor that allowed them to do this. So it's important that training is provided with all tools. Now, holding, disbursing, and accounting for trust money. Except as otherwise provided, a law practice must hold trust money deposited in the law practice's general trust account exclusively for the person on whose behalf it is received, and disburse the trust money only in accordance with a direction given by the person. It is critical that you are clear on who you are holding money for before you disburse any money from the trust account. Now, if you're interested in reading more about this, I'd encourage you to check out my recent article on the Law Society Journal online, and I have provided a link to it here, called Holding Deposit Money in Conveyancing Transactions. Now, a recent case I was involved in had a principal of a law practice. He logged into his bank account on a Thursday morning to find that 68 million had been deposited into his account. And when we traced it, we found that it came from the Cayman Islands. Now, a legal acquaintance made themselves known later that day to confirm that the money was actually for them. It was for a real estate purchase, and it was okay just to transfer the money across to this other practice. Fortunately, the practitioner reached out to me, and we were able to provide the advice on what he needed to do. We actually had to apply to the Supreme Court to have the funds returned to where they came from. So, what is trust money? Well, trust money is money entrusted to a law practice in the course of or in connection with the provision of legal services by the law practice. And it includes money received on account of legal costs in advance of providing the service, and controlled money received by the law practice, transit money received by the law practice, and money received by a law practice that is subject of a power exercisable by the law practice or any associate of the law practice to deal with the money for or on another person's behalf. Now, the definition of trust money has three core elements. It needs to be money. It needs to be entrusted to a law practice, and it needs to be received in the course of or in connection with the provision of a legal service by a legal practice. And if it has all the elements, then it is trust money. Now, the Law Society has developed a legal accounting handbook, which I've provided a link to here, which includes a trust money decision tree. And this has been designed to assist with the identification of money when it's received. So, how many types of trust money are there? Did you know there are 6 types of trust money? We have general trust money, controlled money, transit money, written direction money, money subject to a power, and investment of trust money. Now, I'll provide you with a quick overview of each one. So, general trust money is about 56% of the money in New South Wales. And this is money held exclusively for the person on whose behalf it is received. There's usually only one general trust account, and each matter is recorded in a separate accounting ledger. And the important elements to remember here are exclusive use and the direction to disburse. Money held in general trust does not earn interest for the benefit of the client. The interest is paid into the public purpose fund. Now, there are some things to remember when dealing with general trust money. The general trust account must be established with an authorised ADI in New South Wales. There are currently 15 ADIs in New South Wales, and these are listed on the Law Society website. If you have a general trust account, then you need to maintain general trust account records, which means that a trust receipt is required to record all deposits into the trust account. Withdrawals can only be made by cheque or EFT by an authorised signatory, and that does include BPay. A trust receipts cash book and a trust payments cash book must be maintained, and a bank reconciliation statement must be prepared monthly. Controlled money. This is about 41% of the money in New South Wales is held in controlled money. And this is money held by a law practice but directed by the client to be held in a special account called a controlled money account. Again, the money is for the exclusive use of the client and can only be disbursed in accordance with the original written direction relating to the money. There are special rules regarding the record keeping of controlled money, but they're not nearly as extensive as general trust accounts. Where a general trust account can be held with an authorised ADI, controlled money can actually be held with any APRA regulated ADI. Now, as of the 13th of March 2025, there were 77, but this list is constantly refreshed. And it's always worth checking to make sure you've got the most current one. Controlled money accounts earn interest, and the client earns the interest on that money. Transit money. This is money received but not intended to be held in trust, and is usually quite temporary in nature while being passed on to a third party. The record keeping for transit money is sufficient information to enable the transaction to be identified. Written direction money. This is money that is held but directed by the client to be held in a special account that isn't a controlled money account. And the main difference here between the written direction and the controlled money is that it can be held at any financial institution, whereas the controlled money accounts can only be held at an ADI regulated by APRA. Money subject of a power. This is where a solicitor is appointed to manage. For example, a solicitor is granted a power of attorney by an elderly client to manage their estate and pay living expenses from it. And the final one, investment money. This is money received by the solicitor that is designated by the client to be invested on their behalf. Money received by the law practice for investment purposes is not trust money unless the law practice receives the money in the ordinary course of legal practice and primarily in connection with the provision of legal services, and the investment is made in the ordinary course of the legal practice and for the ancillary purpose of maintaining or enhancing the value of the money or the property. So, before we go on to that one there, what is not trust money before we skip on to the next one? Money that is paid for legal services, if the work has already been completed, is not trust money. And money received for purposes not relating to legal services, for example, a gift or donation, is not trust money. So, keeping trust records. Now we know what is and isn't trust money. How do we keep the records? The uniform rules prescribe in some detail how the trust records are to be kept. Section 147 demands that the records indicate the true position in relation to the trust account money received from any person, and that they are always kept in a way that they can be investigated at all times. Records must be maintained in a permanent form, which means capable of being printed and in English. Monthly backups should be maintained, and best practice is to ensure that they are kept at a separate location. Is there a question coming through? Trust accounts must be maintained for a period of 7 years after the last transaction or finalization of the matter, whichever is later. Now, a number of common mistakes I see and are reported in the external examiner's report arise from timeliness, things not being done on time, adjustments not being dealt with, payments and receipts not being recorded in a timely manner. So, some tips I share with practitioners to remember when undertaking the monthly reconciliation is to ensure monthly reconciliations are prepared within 15 working days. Ensure unknown receipts of money are investigated. Ensure unexplained transfers, adjustments, or payments are resolved. Ensure prior month adjustments are resolved. And like a fire drill, have you ever checked to see if you can restore your backed up records? We've had a recent case where a practitioner's records were destroyed by an office fire, and the last backup they had done was 6 months before. So they had to recreate 6 months worth of client files. So, what are the key dates you need to put in your calendar? I've included some here that you can save as calendar reminders just to help make the whole process a little bit easier. Statutory deposit. If you have a trust account, I recommend you open a statutory deposit account at the same time. Each quarter, you are required to review the balance in your trust accounts. If it falls below a certain threshold, then you are required to transfer a contribution into the statutory deposit account from the general trust account. It is all trust money. But the statutory deposit account earns a higher investment return for the public purpose fund. And the public purpose fund is used to support community oriented initiatives such as the pro bono scheme, solicitor referral services, and it funds regulatory activities. And the real benefit of statutory deposits is that lawyers don't have to pay for regulation. We have developed a calculator. Is there a question there? To support the profession calculate their quarterly contribution. If, for whatever reason, you are unable to contribute in a specific quarter, for example, you're expecting to make a payment or an imminent disbursement from the trust account, you can request a determination from the statutory deposit. And on to the most exciting time of the year because it's days away, 31st of March, trust year end. We've recently launched the Trust Lodging portal to streamline and enhance the process of complying with your annual obligations to lodge a Part A, B, and the external examiner's report. Now, this often causes confusion, but just to clarify, every law practice with a New South Wales Principals Practicing Certificate must submit a Part A. Now, these Part A's will be generated on Monday, 31st of March, so should be ready to complete by Tuesday, the 1st of April. In accordance with Rule 54 of the Uniform Rules, a Part A is required by 30th of April, regardless of whether trust money was held or received. A Part B then is required by 31 May if trust money was held or received during the trust year. And in accordance with Section 155, the trust records should be examined by an external examiner. So you might be saying, who are these external examiners? They're the cool accountants. An examiner is either a member of the Chartered Accountants of Australia, New Zealand, a member of CPA Australia, a member of the Institute of Public Accountants, or a registered auditor who has completed the external examiner course. Now, deficiency in a trust account. What do you do? Section 148 states that a law practice, an Australian legal practitioner, or any other person must not, without reasonable excuse, cause a deficiency in any trust account or trust ledger account, or fail to pay or deliver any trust money. Now, you will note that deficiency is not defined, but I recommend best practice in this area to include Regularly reviewing your ledgers to ensure there are no deficiencies, and restore all trust deficiencies from the office account if necessary. A recent case I was involved a practitioner who'd been subject to a cyber incident, and over $3 million had been withdrawn from the trust account, stolen by the cyber criminal. I had to freeze the trust account until the trust account efficiency was restored. So it's just important to remember. Reporting irregularities. Section 154 states that solicitors must report all trust money irregularities or suspected irregularities, regardless of the monetary value of the irregularity. You will note that irregularity is not defined, but I take irregularity to include intermixing trust money with other money. For example, when a client deposits trust money into the office or general account. A deficiency in any trust account or trust matter ledger, resulting from paying more from the matter than the balance available. Using trust money for office or personal expenses. For example, making payment from the wrong account. Receipt of trust money from unknown or unexpected sources. Cybercrime, cyber fraud, email fraud, direct debits, PayPal payments from the trust account, and anything relating to business email compromise. Failing to maintain accurate records of trust account transactions, failing to properly disburse trust money to the intended recipients, failing to pay barristers' fees or third party disbursements, failing to reconcile trust account balances, failing to obtain proper authorization before making withdrawals from a trust account. Now, I've provided a link here in the PowerPoint slides, which you will get at the end. I provide a link to an article I did recently if you are interested in finding out more about trust accounting irregularities. So, to sum up trust accounting on a page, where can it go wrong and what things you need to be aware of? The risks: misappropriation of funds, fraudulent activities, unauthorized transactions, accounting errors and omissions. Now, why do you care? Well, you want to protect client funds. You want to maintain regulatory compliance. You want to enhance that transparency and accountability. You want to prevent fraud and misappropriation. And also, you want to protect your reputation. So, what's the best practice you can do today? You can ensure you've got segregated duties, dual authorizations, maintain records, do regular reviews and reconciliation. Ensure anyone supporting you is trained and aware of what are the risks associated with handling trust money. You can report any trust account irregularities to trust@lawsociety.com.au, but also I'd encourage you to liaise with your software provider and your external examiner regarding these risk factors to understand how they might realize within your law practice. I've included a number of resources here today, and they'll be involved in a little click. Hopefully, it works. It does, yeah. Under each of the different pictures, and you can peruse at your leisure. So, the second aspect I wanted to talk to you about today was cybersecurity. Now, oftentimes people say this doesn't apply to me. I don't have a trust account. This applies to everybody, regardless of whether you have a trust account or not, but particularly with a trust account. How well do you understand the threat landscape? Now, I've written this from a trust account perspective, but it is equally applicable to your just law practice generally. Cyber attacks take many different forms, but it's important to remember that fraudsters will always have a specific outcome in mind, and it is important that you understand the threat and know where your vulnerabilities lie. So here are the most common threats I see in trust accounts. First one is credential theft, and this includes phishing. And that's a method to trick users into divulging their login credentials to gain access to an internal network, commonly through an email. Clicking on the infected link or opening an attachment can initiate the installment of malware or load a counterfeit web page to harvest login credentials. Phishing scams remain the top reported scam type in the quarter ended 31 December 2024, with 17,712 reports to the National Scam Centre. This resulted in a loss of about 6.6 million in that quarter alone. Spear phishing is the second one. This is a method to trick users to believe that the email is coming from the bank and is asking for bank account login details. Clicking on an infected link or opening an attachment can initiate the installment of the malware. Payment redirection. This is also known as business email compromise scams. And this is where the scammer impersonates a business or its employee via email and requests an upcoming payment to be redirected to the fraudulent account. This is by far the most common threat to trust money. In November 2023, the Australia Banking Association, the ABA, announced that the design of the industry-wide confirmation of pay system, with the build and rollout expected over 24 and 25. Now, the confirmation of payee will offer significant protection against false billing scams by making quite clear who you're making the payment to. And the top three types of contact by scammers continues to be text message, email, and phone call. And ransomware. This is a method to lock victims out of their computers by encrypting them with malware. The damage is only reversed if a ransom is paid. Ransomware attacks are now evolving into data breach territory, and ransomware attacks have risen by over 13% of the last 5 years, with an average cost of about 1.85 million per incident. Now, you may recall the recent HWL Ebsworth cybersecurity incident, which started out with what looked like quite a harmless spam email. The email, um, s- the emailer, the cyber criminal, identified themselves as part of the APHV, who were a Russian-linked cybercrime group known as Black Cat. And they had said that 4 terabytes of data, which is about 2.2 million files, had been downloaded, and they wanted a $5 million ransom. Now, the ransom wasn't paid, fortunately. Never, ever, ever pay a ransom. And you might say, why? Because you're dealing with a criminal. They're not honorable business people. There is no guarantee you'll ever get your data back anyway. 92% of companies who paid the ransom didn't. Paying actually encourages more criminal activity. And to give you an example, in 2020, there were 4 major ransomware groups internationally. This has ballooned to 20 in the last 3 years. So, with earnings of about 91 million a year, they see it as a lucrative business. So, let's not make their job easy. And what's interesting is 80% of companies who were targeted were actually targeted again a second time, sometimes within 2 weeks. So, companies didn't learn their lesson to sort out the vulnerabilities from the first time. 40% of companies who did pay a ransom were targeted again, and 70% of those, the ransom actually doubled. And the average ransomware payment in 2023 was about 1.5 million, with over a quarter of the ransoms being $5 million. So, how long does it take to crack a password? Well, if you think about your own personal password that you use for your online banking, your email, your account access, do you use dictionary words? Do you reuse passwords across applications and websites? Or has your password ever been stolen? Now, you might say to me, Sharon, how would I know if my password has ever been stolen? You can actually check it. So I've included a link here to the Have I Been Pwned, and yes, that is the correct spelling, website. And what you can do there is you can actually check your password, but also your email address to see if they've ever been leaked as part of any data breaches. And if you're wondering how long it would take a hacker to brute force attack your system, this is where they use the trial and error to try and crack your passwords, your login credentials, and encryption keys. It's quite confronting, isn't it? You may wonder, why is Australia being targeted? Well, yes, Australia is most definitely being targeted, and we know specifically they're targeting law practices. And the reason for this is over a third of Australians use the internet for more than 6 hours a day. And in 2013, the average number of devices connected to the internet per household was about 7. This has tripled to 22 over 10 years. So it's easier. for the criminals to attack. So, in a positive note, how do you protect yourself online? There is a way. Have secure passwords. Length, complexity, and uniqueness. These are the golden rules of improving your password. Don't use the same password for each website and application. It's the equivalent to walking away leaving your key in the front door. Activate multi-factor authentication. One version of which is the common two-factor authentication. This has been provided by a lot of websites. This is an easy way to significantly improve your password security. Now, with multi-factor authentication activated, a hacker might guess your password correctly, but they still can't access your account because they won't have the code that's sent to your mobile device. Use a password manager. Now, this is the easiest way to manage all of your passwords. But shop around, as not all password managers are created equal. The best password managers deploy a zero trust security architecture that makes it near impossible to obtain passwords stored in their vaults, even if a hacker breaches their systems. Now consider using passphrases. In recent years, against the backdrop of cyber attacks and data breaches, some cybersecurity experts are starting to suggest using passphrases because they're quite lengthy. And it takes hackers a long time to crack these. And they won't necessarily apply the same rigor to cracking passphrases as they would with passwords. And another one is to use spaces, if your system allows it. It's another way of adding a layer of variability to the password. Learn how to recognize and report scams. So I've included a number of short videos inside here that are taking you back to the cyber.gov website, which is really cool ways to find out about what the most common reported scams are and learn how to identify them. Watch out for threats. Update your personal devices. Set up and perform regular backups. And turn on multi-factor authentication. I do recommend checking these out in your own time. There are a number of resources available to assist you, your team, colleagues, friends, to test your cybersecurity awareness. And I always recommend doing this. The assessment results can be confronting, but it is important to continuously strive for improved cybersecurity awareness. I've also included a link here, the enroll here part, for a free cyber warden training course. And this is something I recommend everyone does. In August 2024, the Victorian Legal Services Board and Commission announced minimum cybersecurity expectations for law practices and lists examples of unacceptable cybersecurity practices that they consider capable of amounting to unsatisfactory professional conduct or professional misconduct. So, the insurer here in New South Wales is Law Cover. I understand they do provide insurance cover across Australia, so you may be aware of them, but they have developed a number of resources with those, which are available on our website. And I've included a link to each one of them behind each of these pictures. Hopefully it works. To provide really good support and tools. And one of them is particularly good to give to clients. And that's really to raise their awareness that you will never change your bank account details and the process of how they can confirm the bank account details with you. It's important we do that. So, what's happening over the horizon? Some trust account emerging issues. So, the first one is checks. Checks are transitioning, in case you've missed that one. In December 2023, the government released its strategic plan for the Australian payment system, with the intention to wind down the check system by no later than 2030. In November 2024, the government released its check transition plan to set out the two-phased approach to shift away from the use of checks. So phase 1 by 30th of June 2028, phasing out the ability for consumers and businesses to write checks as a form of payment. Cease issuing personal, commercial, government and bank checks. Checks written after this date will not be accepted and no payment will be made. And phase 2, on the 30th of September 2029, stopping financial institutions from accepting checks as a form of payment, effectively closing the check system. Now, we know check usage in Australia has dropped 83% over the past 10 years, with less than one check being written per person in 2023. This is down from 50 in the mid 90s. Checks comprise 0.2% of non cash retail payments in Australia. Now, it's important to note bank checks do not go stale. The financial services industry is exploring options to continue to honour any unpresented bank checks, should it be needed. Foreign checks are no longer accepted in overseas currencies. The ABA, the Australian Banking Association, advises the best solution is to ask the overseas institution to use the SWIFT system, and this is the Society for Worldwide Interbank Financial Telecommunications. And this facilitates secure and swift international payments between financial institutions worldwide. And the government has said they expect the financial services industry to play a leading role in the check transition so that all customers that use checks are to be supported during the transition to ensure readily alternative payment methods are available. Now, we've already seen some smaller institutions withdrawing from the check system. And while digital payments have largely replaced checks, the government recognises the ongoing importance of cash in the economy. With about 1.5 million Australians relying on cash for more than 80% of their in person payments, cash still serves as a vital backdrop during natural disasters or digital payment outages. And the RBA's sixth triennial customer payment survey, bit of a mouthful, found that most in person payments are now made by tapping cards or mobile devices, with cash transactions reducing from 32% to 15% over the 3 years ending in 2022. But it is still estimated there's about $60 billion worth of banknotes in circulation. Now, that's about $2,600 per person here in Australia, so some pretty well stuffed mattresses. On the 10th of December 2024, the Anti-Money Laundering, Counter-Terrorism Financing Amendment Act 2024 received royal assent. Practitioners, as well as the other gatekeeper professions that provide a designated service, will be regulated under the new Act. And the designated services including buying or selling, transferring real estate, legal entities, receive, hold, control, or manage funds and or property, for example, money, accounts, securities, or assets, sell or transfer a shell of company, carry out some transactional work, including equity and debt financing, and create or restructure legal entities or legal arrangements. Now, there is more information and rules still coming in that space, so it's very much an active space. There will be a staged commencement for solicitors who provide designated services. Solicitors will be required to assess the services they provide and any associated money laundering and terrorism risks and enroll with the regulator, who will be AUSTRAC. The obligations for solicitors providing a designated service will broadly commence in July 2026. However, captured solicitors should be aware that considerable preparatory compliance work will need to be undertaken prior to the formal obligations commencing. Now, here in the Law Society of New South Wales, we have a team called the Professional Support Unit, and they've got a dedicated AML hotline, so you can send through any queries to them. And obviously, the trust year end. Very exciting time, 31 March. Get your Part A's in. And I'm also in regular contact with our trust accounting software providers, and thank you, Wiseowl, as well, to ensure that our trust accounting software is innovative and it complies with the international data and cyber requirements. And we're always looking for ways to improve upon it. We have regular interaction with international regulators too, to ensure that our regulatory approach is fit for purpose and best practice. And we also have regular meetings with the banks and the ADIs to ensure that trust issues are escalated and resolved as expeditiously as possible. And just go a little bit more into the AML Hub. So the Law Society here in New South Wales provides a lot of resource for practitioners, which is well worth checking out. Now, I've included a link here to a free course, which is an on-demand interactive course. And I really recommend you doing that. It's a really good refresher and introduction to what the requirements are and what's actually happening. It's self-paced, but it provides you with scenarios and suggestions on how to address the risks. And I've also included here the Law Council. They've provided and developed several guidance notes, and I've included each one of them here with a link to it. They're really well worth reading from a point of view of understanding what money laundering looks like, what are the risks, what are the flags that they could eventually present in your law practices. What I have then is the closing part, provide my contact details here. If you do have any questions for me today, or if you want to send them to me afterwards, feel free to. But a huge thank you to everyone for staying and being present here for this today. And thank you to Wiesel and Karen and team for asking me to come here.
Thank you,
Sharing my
Sharon.
screen there.
My goodness me. That was the most interesting talk I've ever heard about trust accounting.
Ah, cool.
And your accent, I could listen to that all day. I love it. So thank you so much. Now, have we got questions? Don't all speak at once. I'm the only one that's put anything in the comments even. You made me very grateful, Sharon, about the fact that Queenslanders are free of special deposits.
I'm trying to make it easy for my poor practitioners in New South Wales.
There's quite a lot of celebration when they were done away with, which is probably close to 10 years ago now.
Yeah, it is interesting to see, particularly where practitioners are operating across jurisdictions, that they've got to address the requirements in each of the different areas.
Mm. So, have we got any questions?
Surely we can't have no questions. Or maybe everyone fell asleep today.
David, Caroline, Kelly, questions, comments?
Even feedback wasn't what you were hoping.
Cheeto, Nav. I'm surprised even Gemma hasn't got something to say. Okay, well,
we've got a couple of things coming through just now. David Squires is saying in Western Australia, I think boat is allowed. Nav is saying, thank you so much. You managed to make a very uninteresting topic into a great presentation.
Oh, Nav, I love trust accounting. Yeah. I could talk about it all day.
Oh, there we go. David's just clarified in Western Australia, I think BPay is allowed.
BPay is allowed in New South Wales. So BPay is a form of electronic funds transfer. And it's just a mechanism whereby you can pay as long as there's a BPay user. The challenge can often be that you may not be able to establish and link your trust account to a specific BPay user. So that's often some of the restrictions with it, but you definitely can pay from a trust account to a BPay code.
And that's quite helpful because it could be a lot of outlays with biller codes.
Yeah. So I tried to take a pragmatic approach. So if the Reserve Bank have approved it as a payment mechanism, it's pretty okay.
Mm-hmm. All right. Well, everyone who's been part of this, we will send you out a copy of the slides afterwards with all Sharon's wonderful links on them. And certainly, if you've got any questions or you'd like to know more about Wiesel, certainly reach out and we'd be happy to help. And next month, we're having it a week early for our next learning table. It's how to increase productivity in your law firm. So thank you, everyone. And we'll wrap it up there. Thank you.